In the matter of A.T. versus M. Cohen, M.D., can we please have appearances?
On behalf of the respondents, Dr. Cohen, Dr. Cohen, Dr. Tran, Nurse White Galliola, and York Digital Medical Center.
Welcome, counsel. And I wanted to tell parties in amici at the outset that we're here on the basis of a dissent, and the constitutionality of the statute was not part of the appeal of rights. So to the extent that's part of any arguments that you want to present, please rest on your papers for that and focus on other items instead. Mr. Roth, you may proceed.
Chief Justice Rabner, Associate Justices, I thank you for this opportunity to appear before your honors. And the fact that we said good afternoon to one another, I will get right to the point. This is an affidavit of merit case. I'm sure your honors have heard other cases in this field. In this matter, we assert that the trial court erred in concluding that it lacked discretion to grant plaintiff's motion for a voluntary dismissal of the complaint without prejudice. And
Was it voluntary or involuntary? I misheard you.
My motion was under 437(1)(b),
Which is
would
involuntary.
be a voluntary dismissal without prejudice.
Did the defense agree to that?
But
Did
the defense did not agree, and that's why we're here.
So that would be an involuntary dismissal without prejudice.
Right.
Not voluntary,
No.
but involuntary.
Basically what happened was I came in at the 11th hour right before a motion for summary judgment was to be argued. I convinced the trial court to adjourn the motion. I filed a motion to permit the minor plaintiff, on behalf of the minor plaintiff, to file a motion to permit a voluntary dismissal without prejudice under the circumstances. And then obviously the reason we're here today is the fact that there was a dissent in the appellate division by Judge Fisher. And what Judge Fisher's dissenting opinion highlighted to me seems to be the crux of the matter. And what Judge Fisher specified was that there were special circumstances in this case that would allow and permit a voluntary dismissal without prejudice because of the fact that the plaintiff was a minor and there were special circumstances, and because of the fact that this court has always been solicitous and protective, to quote Judge Fisher, of minors. Now, I am not here to indicate to your honors that everything that was done before that motion was appropriate or anything of that nature. I am here for the purposes of protecting the rights of the minor. I want that person, A.T., to have the ability to file that claim under appropriate circumstances when the statute of limitations is years away. Now,
so you want one rule for attorney confusion that applies for a plaintiff who's a minor versus a plaintiff who is an adult. Is that the essence of your position?
The essence is putting aside, and there were a number of issues that complicated this matter, not just some problems with prior counsel, that the courts, and I think Judge Fisher brought this out, have always looked at minors in a, as I mentioned before, in a solicitous manner, in the sense that protecting the rights. For instance, and Judge Fisher referred to the fact of the wrongful death statute, a strict 2-year statute of limitations, but we're going to treat minors differently. Or the very fact that when there is a settlement and the settlement goes to a minor, this court, this judiciary steps in to protect the minor.
Can you give us an example of any way in which this court has ever said that when it comes to compliance with court rules, attorneys representing minors are held to a different standard? I'm not talking about statute of limitations or a friendly with respect to a minor settlement, but attorneys are held to a different standard than attorneys representing adults.
I think that attorneys should be held to a same standard.
I'm sorry to interrupt, but I'm asking you for, you're saying that there's precedent for treating minors differently, and you use the examples of statute of limitations and a friendly. Okay, so my question is whether there's any precedent for this court saying that when it comes to compliance with either a statutory requirement that has an impact on the judicial process or compliance with court rules and the requirements that they impose, attorneys for minors are held to a different standard than attorneys for adults.
I don't believe that attorneys for minors should be held to a different standard. I don't believe that's the issue in this case. What I believe is the issue in this case is how the court, under certain circumstances, is going to deal with a situation or a condition involving a minor that could be catastrophic for that minor.
So let's take what we said in Ferrara and see how it applies here. I'm going to read a sentence from it, because everything is stemming from the Ferrara case. And this is what we said. If defense counsel files a motion to dismiss after the 120-day deadline and before plaintiff has forwarded the affidavit of merit, the plaintiff should expect that the complaint will be dismissed with prejudice, provided the doctrines of substantial compliance and extraordinary circumstances do not apply.
Correct.
Okay? So, in order to fit with an exception, you're looking for extraordinary circumstances.
I am looking for either extraordinary circumstances or, as Judge Fisher has intimated, a third category of this court watching out for minors.
So why don't you stay with the framework that Ferreira had laid out and tell
Okay.
us your strongest argument for why the status as a minor should qualify as an extraordinary circumstance.
Well, this circumstance should qualify as an extraordinary circumstance. And the circumstance includes the fact that there was involved here a minor. And what I'm talking about is there was a panoply of problems in this case. That, number one, okay, the plaintiff is a minor.
So
Number two, there's no statute of limitation
Was there a
problem.
Ferrara conference here, counsel?
Pardon?
Was there a Ferrara conference here?
That was my number three. Number three, there was no Ferrara
Does that
conference.
change the equation now? Because had
Well-
there been a Ferrara conference, although from what I read from the record, your prior counsel was less than candid with the court about why you didn't have an affidavit of merit. Does that change the equation because there was no opportunity to address the failure of the affidavit of merit?
There was no affidavit of merit. There was no Ferrara conference. There was no communication indicating that there should be or should not be. And I'm aware of the Paragon case that talks about the fact that simply because the Ferrara conference didn't occur in and of itself is not an extraordinary circumstance. But what I am saying to you is...
Are you asking us to reconsider
No. What I'm asking...
Let me finish my...
Okay.
He's trying to help you.
Okay.
It may be.
Listen closely.
Okay.
He's trying to help you.
Thank you very much.
Are you asking us to consider the lack of a Ferrara conference as an extraordinary circumstances, particularly given the fact that we have mandated that trial courts provide these conferences to avoid the very situation that occurred in this case?
What I am saying is...
Because Ferrara presumed that there were going to be ineffective attorneys. It presumed it. We wouldn't have required a conference otherwise. And therefore, the lack of a conference failed to avoid the very situation that we contemplated should not be occurring. Go ahead.
In this case, the lack of a Ferrara conference is one of several factors that end up being part of an exceptional circumstance situation. And as I said, I've indicated other factors as well.
Like what other factor? We're dealing with an ineffective attorney. Had the attorney been familiar with our rules and our case law, he would have filed the affidavit, correct?
One would presume that, yes.
So
Here, but
And if we were looking at extraordinary circumstances for the attorney, it focuses on the attorney, not on external things, like what was extraordinary about why he didn't file. And it can't be the juvenile, that it was a juvenile. It would be the same for an adult.
I understand, but what Judge Fisher was saying in his dissent was that the very fact that we're dealing with a minor, and the very fact that there was so much time left over for a statute of limitations, in addition to these other circumstances, that the attorney was unfamiliar with the rules and the Ferrara case, and obviously Ferrara conference, and the very fact
somehow
of the Ferrara conference not occurring, when you put those all together, that equates to an exceptional circumstance where, and then we add also that there was essentially no cost or there was,
Well, let me ask you about that. Generally, courts are reluctant, trial courts, to grant involuntary dismissal with prejudice by order when the defense objects because of the expense of the depositions, all the discovery, the experts. Did any of that occur in this case?
nothing happened in this case.
There were no.
That was
there was
my
no
next
pretrial
step.
discovery.
There was nothing that occurred in this case. There was no discovery. In fact, one of the defendants wasn't even served, or if it was served, never answered. So we have one defendant out there who was not even engaged in the case yet. We've got multiple defendants represented by one law firm. There was no exchange of any discovery whatsoever.
That's
In
going
other
to be
words-
that's going to be typical because everything has to occur within 60 days, or at the outermost 120 days.
I understand.
This was, I mean, the purpose of the statute was to get rid of unmeritorious lawsuits
Right.
as early as possible before discovery.
Right.
That's exactly what the legislature did not want to happen.
Well, and here we add that to all of the other extraordinary circumstances, and there's no costs, significant costs to the defendant. And as a matter of fact, at the time of when the motion was heard for a voluntary dismissal without prejudice, it was stated that the prior firm would have no problem agreeing to reimbursing defense counsel for whatever costs they had in terms of filing an answer, interviewing their clients, filing the motions, anything of that
So
nature.
this would hold true for juveniles and adults.
Right.
But so we said in Ferrara, if you don't file within 120 days, and the defendant files that motion first, you're out of luck, barring extraordinary circumstances
And-
or substantial compliance. We said that. We wanted to be
I
clear to
understand.
the bar.
I understand.
But we've
And
also said,
yeah.
and if I can borrow Justice Alvin's term for a minute, isn't your best argument that the Ferrara case, Ferrara conference did not happen, and we have said in Nora that in the event that the affidavit has not been served, the court will remind the parties of their respective obligations. We trust that the early court intervention will make the circumstances of this case unlikely to reoccur. It's a fail-safe that didn't happen.
It didn't happen. And it's part of what I am suggesting to your honors, that it involved this situation of exceptional circumstances.
Mr.
Because it was a confluence of circumstances. Now, the affidavit of merit was initiated. The purpose of it was to weed out meritless cases. And there is a notation in the record here that the prior law firm, after the motion was filed and after 120 days, which I understand in other cases didn't cure anything, did serve an affidavit of merit.
It's part of your.
Okay.
It's part of your argument that, in large part, the problem here was created by the judiciary's failure to enforce its own rule of requiring the conference, and that this innocent child should not suffer.
Yes.
Okay.
Mr. Roth, in your experience, we've made strides, the judiciary's made strides with the e-courts project that is underway now in recent years. Would there be any reason to object to automatic notice, electronic notice going out in the future, if we could do it, after an answer is filed in a malpractice case, neutral notice to all parties saying, be aware of the affidavit of merit requirements?
I think that's a fantastic idea, number one. And number two, in my practice, and I know in other practices, when we file a medical malpractice case and an answer is filed, the first thing my staff does is contact the court within days to determine when, once an answer is filed, to determine when they're going to schedule the Ferrara conference. Because when I hear that, I contact my adversaries, so we're all on board on that. That's an important thing.
Suppose we could also give automatically schedule electronically the Ferrara conference.
Absolutely. I think that would be, and I think it would be helpful to any law firms that perhaps don't do this as frequently as others, or perhaps from other jurisdictions that think that everything is the same wherever they practice.
And I
Some
hope Mr.
counties
Poe-
do that
I
automatically.
hope Mr. Poe can weigh in on this. I'm sorry.
Go ahead.
Later.
So some counties do that automatically. As soon as an answer is filed, a
That's
letter
right.
goes out, schedule, and the Ferrara conference is on order. Those counties have really good presiding civil judges.
But I think our electronic system that is being
Now.
put in is going to centralize it, because as of last year, each county was doing it totally differently.
Now, you're not arguing, for example, if the court sends out a notice that a Ferrara conference is going to be held and lawyers being busy don't get to it and postpone it, that there would be a defense to a dismissal. In other words, if the lawyers just don't get, if they ask for an adjournment, it doesn't happen.
I wouldn't say that, but in my experience, Your Honor, I have never experienced a situation where either my office or defense counsel's office has asked for an adjournment of a Ferrara conference. I have never seen that happen.
In other words, you're not suggesting that that dismissal should not be, the remedy of dismissal should be withheld if the conference isn't held for a reason other than it was not initiated by the courts.
No. In fact, as long as everyone is aware that a Ferrara conference has been scheduled, to me, that is enough information to move forward.
And usually the only way to cancel the Ferrara conference is for the defendant to say that he has received the affidavit of merit, and it's not required. We don't require this conference.
Many practitioners, and our office does this, and many other practitioners typically obtain affidavits of merit before the lawsuit is filed, and in many instances attach it to the complaint that is filed and served. And we don't run into this problem. My concern in this case, and the reason I jumped into this at the very last minute, was the fact that I was concerned that this child was going to get bounced without ever having a chance to have her case heard.
Well, it would have been converted into a legal malpractice case.
You know, I've heard that argument before, but that creates an incredible complex problem, because a case like that, you still have to prove the case within the case.
Right.
Yeah.
So that person would be, that minor, that child,
He'd have to prove the case that he had.
forced to prove two cases.
He'd have to prove the case he had. Number one, he'd have to prove in the
Right.
first place. Plus, the ineffective assistance of counsel would be pretty easy, right?
But he would still have to go through two different cases.
Anything? I think we understand your arguments. Is there anything you'd like to add?
No.
Thank you.
Thank you.
Mr. Comer.
Good afternoon, Mr. Chief Justice, Justices. I appear today as amicus on behalf of NJAJ, and I urge the court to consider the concurrence of Justice Long in Ferrara, as well as the dissent of Judge Fisher in this case. I think Judge Fisher recognized the long jurisprudence in this court of protecting the interests of minors from situations like this, especially in cases where there is negligible, if any, prejudice to the defendant in the case. We've gone over a number of the issues in this case, but I'm not here necessarily just to talk about AT. I'm here as a friend of the court to talk more generally, perhaps, and I offer the court, I think, Mr. Chief Justice, your suggestion that a notice go out at some point electronically before the 60 days, before the 90 days perhaps, scheduling a conference. May I suggest that because we're dealing perhaps here with attorneys that are not the most familiar with our cases, that it not be called a notice of a Ferreira conference, so that they might not know what that is. That may have some language in it regarding the affidavit of merit.
And that's what my question was, whether there should be some general notice about the affidavit of merit requirement and separately scheduling a Ferreira conference.
Well, there is general notice. It's, if you know the case law, you know about it, but unfortunately, I think there are about 10 appellate division cases every year that come out. Not all of them reported. And I believe this court has had, at least 6, maybe 10 cases involving the affidavit of merit statute. So the amount of judicial time that's taking up with this is substantial. I think, Your Honor, or Mr. Chief Justice, your suggestion is terrific, and it might very well cause many of these types of issues to dissolve. However, I would also offer that perhaps the court could tweak the Ferrara rule. You've already expanded the 120 days in Ferrara to some other number depending on when the motion for summary judgment is filed. That might be 3 days, as in this case. It might be a couple weeks. It might be a month. We don't know how much Ferrara extends that requirement. If the rule were, in the absence of a Ferrara conference, if the motion for summary judgment is made after 120 days, the summary judgment will be granted with prejudice if the plaintiff has not presented an affidavit of merit by the return date of the motion. That would probably eliminate the vast majority of these cases.
Doesn't that defeat the plain language of the statute?
Well, the plain language of the statute
It says 120 days, you're out.
If that were the case, then the Ferrara rule would not be that you can file it after the 120 days just so long as the defendant hasn't moved yet. This court has already extended it beyond the 120 in Ferrara.
Yeah, but
And
you're
there have been other
suggesting after
cases.
the motion's filed that we change the language of the statute to allow the affidavit to be done by the return date of the motion.
I'm sorry, I didn't hear the first part
I
of
said
your
you're
question.
suggesting that, in this case, in your suggestion, you have the motion for summary judgment is filed, not like Ferrara, and then you suggest that we should make the affidavit due by the return date of the motion for summary judgment.
Yes, Your
And
Honor.
I'm saying, doesn't that contradict to the plain language of the affidavit of merit statute?
Well, the
Ferrara's
statute...
different.
Whether we use the Ferrara language or my proposal, we're already going beyond the 120 days, which is what the plain language of the statute
Ferrara was
says.
trying to spur all the parties to do their jobs in a timely way, and that included defense attorneys. So one part of Ferrara said, if the defendant does not file the motion to dismiss until after the plaintiff is given the affidavit, and the affidavit is on the 123rd date, then the defendant shouldn't be heard to complain. They should have filed it earlier. But Ferrara also was intending to spur the judiciary to do its job, to file these, to actually conduct these conferences, which unfortunately we know all too frequently doesn't happen. That's the reason why you're here today.
That's one of the reasons we're here today for certain, Justice Albin. But you did say something else in Ferrara, and you wrote that the statute was not intended to reward defendants who wait for a default before requesting that the plaintiff turn over the affidavit of merit. And that's what has become the practice. The defense counsel waits till the 120th, 121st day. They don't call the adversary and say, hey, you got an affidavit after the 60 days runs.
I am not my brother's keeper. We can't ask them. That was the whole purpose of the Ferrara conference, is so that the defendant didn't have to look after the plaintiff. The court was supposed to look after the plaintiff because we presumed a certain percentage of the practicing bar are inadequate and would be inadequate. They wouldn't file we knew they weren't filing the affidavits. So we figured we're going to protect them. The few that don't know how to do it, we'll protect them by having this conference. But unfortunately, the judiciary has been inadequate in actually being able to schedule these conferences.
In some counties, that's correct, Your Honor. Our experience is we file the affidavit of merit when we file the complaint. That way we don't have to worry about scheduling anything. The only issue that might come up is if the answer suggests that the doctor was not practicing within their specialty, then we may have to find a different affidavit. But I believe that if the court were to do what you're suggesting, Chief Justice, that would resolve many of our problems. However, we're here today for AT and what might happen before that. And that's why I suggested to the court that perhaps tweaking the Ferrara rule, that if the defendant does just wait without saying anything and then files the motion, but it's the situation where the lawyer has the affidavit in the file, thought it had not gone out, and sends it right over.
If we start requiring either party to warn the other of potential pitfalls in litigation, there really is no end to that. And there are many requirements. I mean, if for example, you could require plaintiff's counsel to call defense counsel and say, your answer's due, and I just want you to know your answer's due, and I'm not going to give you an extension on it, and I'm not going to agree to a step. That would be a ridiculous requirement.
I'm not suggesting it would be a requirement. I'm saying in a situation where the defense attorney has not written to the plaintiff's lawyer after 60 days saying, where's your affidavit?
But what you're saying is that adversaries should be required to remind their adversaries of a requirement that's set forth in a statute.
Respectfully, Justice Patterson, that's not what I'm trying to say. I'm just simply saying if the complaint gets filed, an answer gets filed, and then there's radio silence on the issue of the affidavit of merit, the court doesn't set up a Ferrara conference, adversary doesn't say, hey, you got an affidavit? I'm not saying they have to. I'm saying in the event there was radio silence, a motion gets filed after the 120 days, but the affidavit is served before the return date. Certainly in the case of a minor, as we have here, because this court has gone out of its way to try and protect minors from people who aren't doing their jobs. And I'll answer your question, Justice Patterson, that you posed earlier, if I may. It's my proposal that under those circumstances, that it's not getting the affidavit in before the motion's filed, it's getting the affidavit in before the return date. You're still within that very finite period of time where there's absolutely no prejudice to the defendants. I know there has been submissions suggesting all these things go on in the first 120 days, but this court in Burns versus Bilewski, Chief Justice Ports, in a very similar situation, said that any claim of prejudice at this early stage lacks credibility.
But you already had, by definition, under that kind of rule, you've already had the expenditure of filing the motion. And you're extending it realistically. We're not talking about a few days. We're talking about with the responding papers, and we've got a pretty extensive summary judgment schedule. So we're talking weeks later at this point.
In this case, the affidavit of merit was filed 59 days after the 120th day.
So here, though, let's deal with what was the law at the time the court faced this problem. The time for filing the affidavit had passed.
Yes.
There was no affidavit. We know there was no Ferriera conference. Defendants argue they're entitled to dismissal. The trial court is being asked to give an involuntary dismissal without prejudice, which she feels constrained against giving under these circumstances. She's faced with the Paragon decision from this court, which says absence of a Ferriera conference does not excuse the non-filing. So the only thing that's being argued to the trial court judge is attorney confusion, the second answer given by the initial attorney to have handled the case, not present counsel. Because originally there was that inaccurate representation about timing of when documents were delivered. Medical records. And this amorphous standard about the fact that we're dealing with a child. So, in fairness to the trial court judge, weren't her hands tied? I mean, if we were to give some relief at this stage, we have to give it with some acknowledgement that the trial court was acting within the confines of the laws that existed at the present time.
I don't fault the trial court at all based upon the state of the law that the judge was dealing with at that time, and Kubiak being the only reported decision on that issue that was on point. I don't fault the trial court at all. I believe the court's hands were tied. What we're asking this court to do is untie the court's hands, and perhaps by tweaking Ferrara, these issues just won't come up with anywhere near the frequency that we're dealing with here. But Kubiak, and to a certain extent Ferrara, goes back to Kornblatt, where the court said any failure over 120 days is automatic dismissal with prejudice absent extraordinary circumstances. And by introducing the extraordinary circumstances requirement into a case very much akin to a statute of limitations argument, because it is essentially you have 120 days. If you don't get it, the case is dismissed. But this is a cause of action that's recognized at common law, and typically this court will look at those timelines with leniency when you're dealing with cases that come to you that were recognized at common
So
law.
ultimately, your organization is not looking for a broader a hint from our court to trial courts to give broader access to dismissals without prejudice when they are involuntary because counsel will not agree to them, are you?
I think the case law on that is that if there's not going to be substantial prejudice to the defendant, and the court can fashion some order to permit the dismissal without prejudice, that the court should do that. And I think I think the trial court was faced with that state of the court rules. However, the court was also faced with Kubiak. And so for this particular cause of action where the affidavit of merit statute was involved, the court was not able to do what the trial judges normally do. Look, you've had no prejudice. To the extent you've had to file a motion, I will order the counsel fees be paid off to you. I'm going to put everybody back in the same position. We're going to do a dismissal without prejudice.
But if a voluntary with an objection by defendant, technically not a voluntary, but if a dismissal is the remedy for a failure to serve the affidavit of merit, if that's the escape hatch by which someone could, within the statute of limitations, simply start over, the legislature's clear intent with respect to the affidavit of merit is defeated, is it not?
No, in fact, by dismissing AT's case, the intent of the legislation is thwarted. The legislature wanted to have a scheme where cases that were non-meritorious would be identified early and taken out of the system. And the second portion of that scheme was that meritorious cases would be permitted to proceed to trial.
But the legislature did not make any exception for counsel errors. I mean, it could have done that.
The legislature made no such exception in the case of the wrongful death statute either, but this court has fashioned remedies on behalf of minors where there was counsel error.
That's a very different, realistically, wrongful death is a very different situation than this, is it not? We're talking about here, we're not talking about whether somebody has an action to bring. We're talking about the adult guardian's election to bring a lawsuit and the requirement that the adult guardian, if they bring the lawsuit, comply with the statute. I mean, the adult guardian could have stayed out of it completely and waited for the child to turn to become an adult and bring her own lawsuit.
Well, in Lefebvre versus Janney, the court was faced with a situation where the adult hired a lawyer on behalf of herself and her children within the 2 years to file the lawsuit, and that lawyer did not bring that case within the 2 years. And the court said, we're going to preserve that lawsuit on behalf of those minors because it's in the interest of justice that we allow that case to proceed. The mother's case, they did say, was dismissed, but the 3 children of the deceased husband, that case was preserved and they were allowed to proceed.
Right, but we're dealing here with a situation where there is a cause of action brought on behalf of the child, and the issue is to what extent is that individual required to comply with the statute?
Well, the action was brought on behalf of the child in Lefebvre as well. Also in Negron, there was an action. The attorney was hired within the statute of limitations. The parent hired the attorney to represent herself and the children. That lawyer filed a case in the wrong jurisdiction and litigated it for a substantial period of time. And it wasn't until approximately two and a half years after the statute of limitations ran that case was filed in New Jersey. And your court in Negron said, we're going to make an exception and apply equitable principles and allow that case to proceed in New Jersey.
So you don't recognize any distinction between the statute of limitations and equitable tolling for minors and this situation? You think that are you telling us they're the same?
Well, equitable tolling for minors and the statute of limitations are not the same, but if you have a situation where the statute of limitations has run, perhaps equitable tolling for minors can preserve that case on behalf of the minor. And that's what you did in Negron, and that's what the court did in Janney as well. Lefebvre versus Janney. So I believe that the remedy that we've proposed, if the court does what has been indicated, may very well resolve, and my argument may be unnecessary, but in the absence of that, I would propose a tweaking to Ferrara, as I have indicated, to make it the return date of the motion, not the filing date. And then we would probably not come back here as often as we do.
Thank you, Mr. Cohen.
Thank you.
Mr. Trullo. Not that we're not happy to have you back.
Chief Justice, Justices. May it please the Court. The Ferrara Conference, assuming Your Honor's suggestion that an automatic notice is set out, can be ignored. That notice can be ignored the same as counsel for plaintiff ignored the law in this case, ignored a demand for an affidavit of merit in the defendant's answers in this case, ignored what is pretty much every continuing education class deals with some type of...
But at least it's the judiciary doing what it said it would do. So in Ferrara, we said we would conduct these conferences. The purpose was, we knew that a certain percentage of the plaintiff's bar was inadequate to the task, and we weren't going to file these affidavits, so we created the fail-safe system. So shouldn't it? So before we toss a case out because of ineffective attorneys, shouldn't we at least be effective ourselves? Shouldn't we do what we promised we would do before we start kicking cases out?
Well, Your Honor, Ferrara was in 2003. This is 14 years later.
That's right, and we're still not conducting Ferrara conferences as we promised.
Attorneys should be obligated to know the law in the
Of course they
jurisdiction in
should.
which they choose to practice.
We knew that in Ferrara. In Ferrara, they were presumed to know the law, and we knew that a certain percentage wouldn't know. They were inadequate. But we didn't want to throw out unmeritorious cases. So the solution was, we'll save them from themselves, we'll hold the Ferrara conference, and that'll be the end of all these cases. But in 2017, here we are.
And if the court chooses to do that prospectively, that could be something that's considered, but certainly that should not be applied retrospectively in this case. In this case was properly dismissed by the trial court, and the appellate division properly upheld that dismissal. A demand for an affidavit of merit was made in the answer in this case. So that demand was made. That notice was given to the plaintiff's counsel. They chose to ignore it. The counsel's suggestion with regard to the timing, in this case, the affidavit of merit by Dr. Boro, which does not name any of the individual defendants, but only names the hospital and practitioners, so I would argue has insufficiencies in and of itself, was filed almost, I believe it was 179 days. But it
Can I back you up? What notice was provided to the plaintiffs and when?
As a matter of course, in answers I file in cases, in my answer is a specific demand that a affidavit of merit pursuant to statute be served.
And do you have any recollection of when in the 120 days that happened? Presumably...
It's in my answer, so that
answer.
triggers
that's the beginning of the 120
so that's
days. Day one.
So that's day one. That's in every answer that's in our office. We send that out. So that notice is given. It is not the obligation of defense attorneys to tell plaintiffs' attorneys how to do their jobs.
And this court has said that.
And I agree. and therefore, but we do put it in our answer, so there is notice. And Your Honor raises a question about whether or not more notice should be given, but how much notice? Then when they ignore it, do you remind them? Do you have a tickler system that the judiciary has to send a reminder every couple of days? There has to be an end. And there is prejudice to the defendants in this case. To say just because there were not significant fees expended does not mean there's not prejudice to the doctors and nurse midwife that were sued in this case.
Well, you're essentially arguing you have some vested right to dismissal of the action.
I'm sorry, I couldn't hear you.
You're essentially arguing that the defendants have some vested right to dismissal of the action once these time periods and the failure to file the AMS, the affidavit of merit, passes.
That's correct.
But why did the trial court not have some residuum of discretion to grant an involuntary dismissal without prejudice under these circumstances?
Because the application to grant the dismissal without prejudice, whether we call it voluntary or involuntary,
right,
it would have been used to subvert the meaning of the affidavit of merit statute. It's clear, Schulis states that you cannot use a dismissal without prejudice to get around deadlines, to get around the fact that you didn't prepare your case, to get around a pending trial date, to avoid summary judgment. So the purpose of the rule permitting the dismissal without prejudice does not allow for it to undermine the purpose of the affidavit of merit.
So was the problem the exchange that took place between counsel and the court as to how much time counsel was asking for in terms of refiling a new complaint now that an affidavit had already been presented, so we know that one was obtainable? This was an open-ended time frame. I think you argued it before the trial court.
I did.
Do you have to wait another 14 years before we see the complaint? And in the meantime, excuse me, all of your clients, or the ones that have malpractice, have to be concerned about malpractice, are going to have the pendency, the notice of this potential complaint hanging over them in terms of potential premium impacts.
That's correct, Your Honor. Premium impacts. Make no mistake that being served and accused of medical malpractice by these healthcare professionals impacts them in their psyche on a day-to-day basis.
So what if the trial court had said, as she originally did, I'll give you 30 days to refile, and that's the extent of my dismissal without prejudice?
I would submit, Your Honor, that it would not have been appropriate and not have saved the complaint in this case, because the dismissal without prejudice, when it was reinstated, would necessarily put plaintiff back in the circumstances they were at the time of the dismissal was entered.
So you want a vested right to dismissal. Once the time period is exceeded, you have an automatic substantive right to dismissal of that action under the statute.
Yes,
Well,
Your Honor.
how can that be, since we've already carved into our jurisprudence in extraordinary circumstances and substantial compliance exception? So we know that there isn't a vested right in 120 days because there are exceptions, correct?
But none of those exceptions apply in this case, and those are exceptions when something's done, not nothing.
I'm just speaking generally, that there isn't a vested right in 120 days if the extraordinary circumstances and substantial compliance exceptions apply, correct?
There are exceptions that have been carved out, Your Honor, but those exceptions do not apply in this case. In this case, it's not a circumstance that there was a confusion over a specialty or a confusion over the qualifications of an expert. This was, or there was, as the recent case having to deal with respondeat superiors and hospitals. There's no confusion. This is clear, black letter, what the statute says. You get 60 days from the answer to file your affidavit of merit. Then the court may grant you an additional 60 days. You don't get 120 days right off the bat.
Right. Another black letter law was there'll be a Ferrara conference at the end of 60 days, correct?
I believe the Ferrara conference
Well,
is 90
Ferrara
days.
said 90, but I
Yes.
think our rules may say 60.
Somewhere
Yeah.
in between there.
Right. So that was another sort of black letter
That
law
was a
there.
suggestion and that was encouraged to be performed by the courts.
Not encouraged, we've mandated it, correct?
But if the courts choose not to fulfill their obligation, it should not be imposed to prejudice the defendants by having these medical malpractice, these professional...
Right, should it prejudice the little child who's going to have his claim turn out?
Oh, Your Honor, once the child has a guardian, once the child hires a lawyer, once the child's lawyer files a complaint, serves the complaint, and an answer is filed, that child is in no different position than an adult. That litigation must move forward as the same as if that litigation was for an adult. And the lawyer has an obligation to fulfill their job and to prosecute that matter in a professional manner in accordance with the standards of care of their profession. So in this case, it's not a circumstance of whether or not somebody knew to bring the complaint. It's very different, a statute of limitations versus the requirement of the affidavit of merit. The affidavit of merit issue is, has the appropriate expert given us, even though it's a small, it's not detailed, it's not an expert report, but has there been expert review that of the medical records that show that this is a meritorious case? And with a minor, it should be even more strictly enforced, because there's no running on the 11th hour to file before a statute of limitations. There's years to get the expert and have the expert review the medical records before you file this case. And when you file this case as an attorney in the state of New Jersey, you should have your ducks in order and you should have your expert. And I understand that there are certain times where the client walks into the attorney and it's adult and the statute is going to run and they have to use their best judgment to see if it's a good case and they file it. But that's not the case with the minor. There was no reason why this attorney couldn't have determined whether or not they had an expert who could provide an affidavit of merit prior to the filing of the complaint or shortly thereafter. So I think actually it's the other way around than we've been talking. With a minor, there's no deadline that requires a plaintiff's attorney to act quickly and without thought and discretion.
Would you agree that if there had been a motion to dismiss without prejudice brought before the running of the 120 days, you would be standing in an entirely different position in arguing against the trial court's right to dismiss that action?
I would still, as the defendant, object to it, Your Honor, for various reasons. However, I think the analysis then would be, would the plaintiff have the ability to get those last, if it was 3 days, if it was 6 months, when you put the plaintiff back in the same position that they were when the application was made to reinstate the case, because that's my position. If a dismissal without prejudice was entered, and then the case was moved to be reinstated, it would still put this plaintiff back where we were on the day the dismissal was entered, when the motion was filed, and there was no appropriate affidavit of merit, and there was no way to proceed with the case. So it would be a slightly different circumstance.
So for all time, that plaintiff would only have 120 days, however segmented, to come up with the affidavit of merit under your analysis?
Under circumstances where there's been no efforts. There are exceptions for confusion, there are of specialties, there are exceptions for having to do with certifications for
Afghans. I understand. You're putting qualifications.
Under these circumstances, where just simply nothing was done until 180 days, there was not an affidavit of merit filed on the return date of the motion. The motion was adjourned without notice to the defendants to another return date, and it was even after the opposition would have been due for that return date that Dr. Burroughs' affidavit, which I still submit as insufficient, was provided.
Thank you, Ms. Strolla. I think we have your position.
Thank you, Your Honor.
Mr. Poe.
Good afternoon, Your Honor. Thank you very much. As may it please the court, as amicus, we're here to share some insight in terms of the outcome of this case and the ramifications this case may have on the insurance industry. And although we don't make up a great deal of sympathy for most people, the insurance industry, it also affects all of our insureds, which in this case are physicians or any professionals that will see their rates go up or have availability a threat to them. So, I'd like to rely upon our briefs and my certification, but I want to expand on it briefly. Our job as an insurance industry is to create some sort of certainty when it comes to what we're going to charge our professionals, or in this case it's doctors, in a field of uncertainty, where we don't know what that exposure is going to be. And this case strikes at the heart of that uncertainty. We set rates based upon what we think we can predict and what we think that outcome would be. If plaintiff attorneys are allowed to simply fall asleep at the wheel regarding doing their obligation of pursuing a case and being able to refile these cases continuously with minors, we will have uncertainty with how much we can charge, in particular, physicians in this specialty are obese. Yes, Your Honor.
If the adults had filed their claim, with or without let's say without an affidavit of merit, and they get dismissed, and 5 years, 10 years, 13 years later, the guardian files on behalf of the minor, you'd be in the same position.
Yes, Your Honor. We wouldn't be in the same position in the sense that in the first 120 days of our suits, it's estimated, and it's not in our certification in complete detail, but we spend about 10 to 20% of our costs in that first 4 months. We send out our files to experts.
That's not what I'm asking. I'm just saying, I understand what you're saying. The minor is going to hang out there until they turn 18. Aren't you in the same position you're complaining about and subject to a valid malpractice suit. If the adults file their claims day one and fail to file an affidavit of merit, you know there's a minor out there, because that's what the basis of the malpractice really is, the injury to the minor. They get dismissed. 10, 12 years later, the guardian files on the minor's behalf. Aren't you in the same spot?
Well, in terms of a total exposure, yes, we're in the same spot. In terms of our expenses related to that exposure, no, we're not. Because
So if costs are assessed, are you in the same spot?
No, because if they're able to refile, I mean, you're comparing this if they can refile all the time and get dismissals because they're minors.
No,
just
I'm not
refile.
suggesting that that would be an appropriate rule. I'm just asking if you're in the same spot under my circumstances.
Under your circumstance, are we still exposed to the same liability?
Yeah.
Yes, the answer is yes, but not expenses and not availability, because we have reinsurers that go based and reinsure our policies. So depending on how large you are, we purchase treaties on our behalf to insure ourselves, and they deal with claim years of when they're actually reported. So anytime you have this uncertainty of knowing when an exposure is actually at risk for us, we have uncertainty with our reinsurers as well.
But don't you have
Examples-
that exposure the minute he files his complaint?
We do have the exposure. The problem is not the exposure. The problem is how we actually build this into our costs to physicians. So in other words, at the end of if we have a claim that's brought up against a physician, let's say in November of a certain year, and it's reported, and we don't know whether or not it can be refiled, we have to actually set up a reserve. We set up a reserve. We might have to trigger our reinsurers to tell those reinsurers, this is what we're going to pay in premium for that reserve of that loss.
And your reinsurance, the reinsurance that is available to you may change based upon when that claim is ultimately brought.
Correct. As well as the fact that the physicians themselves, believe it or not, the largest insurer in the state of New Jersey for medical malpractice determines rates based on what they reserve for a physician in terms of their defense or their indemnity. So subjectively, an insurance company, we're not like car insurance with drivers. We have very few things to predict what our losses and our expenses are going to be. And one of those things are what we call loss runs, which is what we put up for reserves to pay for expenses in terms of a case, as well as the merits behind that case.
So if I have my understanding correctly, that if for example, this case were put on hold through a voluntary dismissal and then potentially could be refiled years from now, the reserve would be put in place for the physicians involved and their rates could be affected.
Right.
As a friend of the court and a representative of industry, do you have any concerns about automatic notice going out from the court, general notice to all parties in these sorts of cases?
I don't have any concerns with that. I think that's a great idea. One of the things I did want to clarify, though, is I believe the Ferrer Court said 90 days on the presumption that a plaintiff attorney would actually comply with a 60 days. So if they go without 60 days without an affidavit of merit, they're supposed to file a motion to extend that 60 days. So I believe this court said in order to make sure that we perfect the correct affidavit of merit, we will have a Ferrer conference in 90 days, which was the assumption that a plaintiff attorney would do their job. And that's what we don't have here. The only extraordinary circumstance here is that we have an attorney that believes that they can actually be here today to argue this case.
But at the conference, if there was no affidavit, the judge was supposed to remind the attorney to file the affidavit within the remaining time. And if there was a deficiency, the defense attorney was obliged to tell the plaintiff how it was deficient, correct?
I was under the impression only in that second part, that the Ferrer conference would only examine the deficiency of the affidavit of merit and whether or not it was the right
Covers
specialty.
both.
Okay.
Anything you'd like to add?
No, thank you very much.
Thank you. Thank you to all counsel. We'll take the matter under advisement. Counsel are here for Akeem Boone and Ronaldo Terrell. We're going to take a recess, be back at 1:30. I apologize for the delay. We have been working, and you'd rather that we be fed before we come back. So we'll start at 1:30.